have in studio here with us Miss Norma Fearon. She's Deputy Registrar of the Matrimonial Division of the Supreme Court. Thank you so much for joining us.
Thank you for having me.
All right, wonderful. So let's get straight into it. Who is eligible for a divorce in Jamaica? You know, how does the process begin, and how do persons get started?
Okay, so either party to a divorce may petition the court. Either party to a marriage, may petition the court for a divorce once they can satisfy the court that they have been married for at least 2 years.
2 years.
And have been living separate and apart for 12 months prior to the presentation of the petition.
Okay. When you mentioned separation, just to be clear, what does that mean? Because in research, I understand that some persons can be living in the same house but still be separated.
Right. You can be living in the same household and be separated legally. As long as you are not cohabiting as husband and wife, and as long as you maintain separate households. So when you file the petition, you must establish clearly how it is that you are living separate and apart.
Meaning, like,
in the same house.
I live in this room and she
or
lives in that
different
room,
sections
or something like
of the house, because some houses are have different sections or several bedrooms. The parties do not cook together. They don't share finances. They don't really socialize. That sort of thing.
But what about situations where they may have children together and so on? How do they make that separation element work when children are involved?
The children, in terms of separation, the children really it is not required, for you to state how it is that they are living in the same household whilst the children are there and still separated.
Okay.
So, you can still have the children there. You need to show who has primary custody and control of the children.
Okay.
And once you can demonstrate, those things, then
it's not a problem.
It's not a problem.
Okay. We were talking about this earlier, but I just wanted to clarify for persons like me who may be curious. Is it that in legal terms, is that one person divorces another person, or is it something that people agree to do together and that kind of thing, or is it, is there a specific way it's phrased in law?
Well, in Jamaica, we don't have divorces by consent. One party must initiate the process, and once the process is initiated and is completed, then the parties are deemed to be legally separated, legally divorced.
Okay. Are there any specific grounds on which persons may file for a divorce? Because what you hear out in on TV and shows and so on is that irreconcilable differences, that catch-all phrase, that kind of
irreconcilable differences is really I would say a vague term.
Okay.
There's only one ground for to obtain a divorce, and that is you must demonstrate that the marriage has broken down irretrievably. And so in the petition, you would be asked to state the circumstances that led to the breakdown of the marriage.
Okay. And so what exactly does, having decided, okay, we want to get divorced, I want to get divorced, what do I do next? What's the next step?
All right. So the next step is to either you in person or you can get an attorney and, provide the person with the relevant information, a copy of the marriage certificate. If there are children, you need to determine whether you want to apply for maintenance, custody. If there are property involved, you want to know whether or not you are going to apply for division of property. So all of those things can become part of the process.
Okay.
Sorry. And once you decide what you want to do, then the petition can be filed in the court.
And by petition, is it that I fill out a form or something like that?
The petition is yes, it is a form. That form is also available on the Supreme Court website. It is a prescribed form. And, certain questions you will have to answer certain questions in the petition to satisfy the court that, yes, particulars of the marriage, where the parties are living, whether there are relevant children, when the parties separated, and all of those things. And the petition must be signed by the petitioner. It must be stamped. And
stamped
then
by who?
Stamped at the stamp office, tax administration, and it is stamped for $5,000.
Okay.
Yes. and then you can file it in the court.
All right, and whether or not you, I mean, as you say, you can have an attorney do it for you, or you can
Yes,
do it
or
yourself.
you can do it yourself. And I must add, if there are any children, and those children are relevant, then you will be required to file an affidavit accompanying the petition. And that affidavit will outline the arrangements that are in place for those children, because the court really will not grant a decree absolute unless the court is satisfied that satisfactory arrangements are in place for those children.
Okay, all right. Okay, having filed the petition, what happens after that?
When the petition, after the petition is filed, it goes through a little process, and then it is reviewed by the deputy registrar. And if it is in order, then it will be signed, it will be sealed, and returned to the petitioner in person or the attorney at law for service on the respondent.
Okay, so basically you're serving the other person, the other party, the divorce papers, for them to get involved in the process now.
Right. So the respondent can now, choose to acknowledge the petition or file an answer to the petition.
An answer meaning some kind of an objection.
Yeah. For instance, if there are children, for instance, they may state in the affidavit that the respondent is providing $2,000 per week for maintenance of the child, or $200,000, and that's not the case. Or they may need additional sums of money. So they will respond.
They want to challenge some aspect of what's going on in the original petition.
Right. Okay. And once they have done so, then automatically the matter will be referred to case management for those issues to be dealt with. Hashed out in a
back and forth kind of way.
Right.
I suppose that can kind of lengthen the process depending on how
exactly. So that is one of the reasons why sometimes the divorce process is so lengthy if it becomes contentious.
All right, ladies and gentlemen, as we said, we're speaking with Miss Norma Fearon, Deputy Registrar for the Matrimonial Division of the Supreme Court. We have her live in studio, so if you have any questions that you want to understand or have answered about the divorce process, just go on ahead, send in your comments, and we'll try to answer them live here with her. All right, let me get back to my questions. One of the things I understand is that the divorce process is in some way linked to citizenship, in that you can have to be a resident of Jamaica to file the petition or something like that.
All right. So the petitioner must invoke the jurisdiction of the court, meaning that the court, they must either be a national of Jamaica or domiciled in Jamaica or ordinarily residing in Jamaica at least 12 months prior to the presentation of the petition. So once they have satisfied either one of those, then the court will have jurisdiction to hear the matter.
All right. Let me come back again. So so we're back at the objection stage, or so we're in the case management stage. And let's say we've managed to somehow hash out things and come to some kind of agreement. What's the step after that?
The application will proceed. I mean, depending on what orders the court makes. Because sometimes the respondent will withdraw the answer. Right, and sometimes the court will order the application to proceed undefended.
Okay, but what do you mean by undefended?
Meaning that they have resolved the issues. So they can now proceed. Right, because it's really a hearing on paper. Yes, it's a hearing on paper.
All right, and then having proceeded, managed, as I said, we worked things out. You were working those. Now, what's the next step after that? How do we proceed from there?
You mean from the?
Yeah, having, I guess, from case management, or having essentially worked out that part of it.
Maybe we should say, if the respondent has not filed an answer.
Right. Yes.
Right. So the respondent perhaps may file an acknowledgement of service indicating they have received the petition, right? And depending on where in the world the person is, for instance, if the person is in Jamaica, they would be required to file an acknowledgement of service within 14 days of receiving the petition and an answer within 28 days. If they are in the USA or the Caribbean, they will be required to file an acknowledgement of service within 28 days and 56 days for an answer. If they are in Europe,
Okay.
except Russia, then it's 42 days for an acknowledgement of service and 70 days for an answer. The rest of the world is probably 84 days.
Okay.
Right.
But does something kick in if you can't find the person, or they don't find a acknowledgement of receipt?
There's a way to deal with that. If you can't find the respondent, then you can always make an application to the court for substituted service. So, for instance, you know that the respondent might be in contact with a relative, right? Or you know that the respondent resides in Queens, New York, but you don't know exactly where. So the court may order or can order substituted service on a relative or by way of publication in a newspaper.
Okay.
Yes.
So you see those things in the paper that such and such is no longer responsible, no longer cohabiting with.
No, you would see. You'll see a notice of proceeding indicating that the petitioner has filed a petition in court. And if you have not responded within a required amount of time, then the petitioner will proceed in default.
All right, and then next step after that, I'm just trying to make sure we have a sequence so that persons can follow along.
So once those time periods are observed, then the next step is the decree nisi stage. And at this stage, the petitioner really is saying to the court, I have served the petition and the respondent has not responded within 14 days, 28 days, or 56 days, and we want to proceed in default. And if all the documents are in order and we are satisfied that the petition was served properly and a search was conducted and certain, an affidavit accompanies that affidavit, then the matter is reviewed again, referred to the judge or a master for consideration. And, if it is in order, they will sign that decree nisi. Right.
And then
it's a three-stage process actually.
Okay.
Once that is signed by the judge or the master, then the petitioner or the attorney will now be required to wait 6 weeks.
6 weeks, 6 whole
right.
weeks. Okay.
6 weeks.
I guess you've been waiting a year, you can wait another 6 weeks, right?
Right. So 6 weeks now before they can ask the court to make that decree nisi final, and that final document is called the decree absolute.
Right.
So that 6 week period is really to see if anybody wants to intervene
or challenge anything that might just come back up out of the shadows.
Once the court, is satisfied that nobody has intervened, then the decree absolute.
So let me ask you this. Under the most ideal circumstances, how long or how short can the process take?
Under ideal circumstances, it can take 4 to 6 months.
Okay.
Because we have statistics to show that, minimum of 6 months. But ideally, if the documents are error-free, usually when you have children, sometimes, that can make the process a little longer. Or if it is contentious, the process can be a little longer.
Of course.
But under ideal circumstances, documents are error-free and everything, is in order.
All right. From your end, 46 weeks.
6 months, not weeks,
right,
sorry.
46 months. 46 months, ladies and gentlemen. I was a slip of the tongue, all right? So in terms of expense, because that seems to be the most intimidating factor why many persons tend not to go this route. Can you say what it might cost a person?
Why would you say that?
How many persons just feel like they feel like there's just a general perception that it's really expensive.
When persons are getting married, you realize that no expenses are spared, right?
Yeah, well, depending on the kind of marriage. There's some people have very RGD
persons will go out of their way to do an elaborate wedding.
Yeah.
But as it relates to fees charged, I am really not in a position to speak to fees. We do not charge fees at the court. In
terms of filing these petitions and so on?
We do not charge fees at the court. Fees are paid at the government office, the tax office, tax administration, stamp office. Because what really happens is that the originating document or the initiating document, which is the petition, that's the only document that you stamp, and that's for 5,000.
Okay.
Right? So you stamp that at the stamp office.
All right.
And if you require a certified copy of, say, the decree absolute, then that's $100, and that's payable at the stamp office. So
Okay.
we are not really involved in.
So it just depends on you, and I suppose maybe your attorney and the whole process, and individually.
Yeah, and I mean,
right, you know.
generally fees will vary depending on the attorney and depending on the issues that may arise,
Okay.
So, I mean,
I mean,
I don't know
you don't
if
think
it's
it's that
expensive.
you don't think the expense is really intimidating or should prevent anybody from
I mean,
following through with
as
that
I
kind of
said
thing?
before, when persons are getting married, no expenses are
You
spared.
make a good point, for
Right.
real. I mean,
So, I mean, and I say I don't really know what the fees are.
Okay.
Really know.
All right.
And they will vary.
All right, Miss Norma Fearon, we have her here in studio. If you have questions about the divorce process, want to make sure you're doing it correctly and, more importantly, legally, please send in your questions. We're here and we'd like to engage our audience. So let me ask you this. Are there changes to the process if the couple has been married for less than 2 years? Or is the process different for couples in that time frame?
If a couple is married for less than 2 years and they want to get a divorce before the expiration of the 2 years, then they can only do so with the leave of the court,
Okay.
right? And the court will only consider such applications if it is satisfied that the parties obtained counseling from an approved marriage counselor, or there are special circumstances that would require the court, that would justify the court granting such leave.
So, I mean, it's not necessarily a preventative thing as
No,
long as it's just...
you just have to go to the court and present your case.
Okay. Another question I have is, I understand that some persons are saying that you might be required to go through marriage counseling as part of efforts to show that it has broken down irrevocable or
Yeah, the
irretrievably.
law
You know what I mean? So,
requires, yes, you're required to do counseling. I mean, the law requires that the court shall give consideration to a reconciliation between the parties.
so is it that the court
And-
is looking to find a way
Well,
to
you
get them
have-
to reconcile?
Well, ideally,
Okay.
the court must determine that the marriage has broken down irretrievably. And an attempt at reconciliation, is really to show that the parties did attempt to, keep the marriage together.
Okay.
So if
Because some person might feel like, okay, I mean, I've already made, that's why I'm here, I made the petition, why do I need to go back and do counseling
if
or
the
something
court
like that?
is on the facts, is not satisfied that the parties or is of the opinion that a reconciliation can take place, then they can adjourn the matter and require the parties to get counseling from an approved marriage counselor, or give them time to attempt a reconciliation.
Okay. All right. Now, you mentioned earlier that there are steps being done to try and make the process a little easier for persons so that they don't try and go the wrong and illegal way or unlawful way. So talk to me about some of those things.
Okay. Well, really, we now have prescribed forms, and those forms came into being in 2015. They were gazetted in 2015. That's Gazette number 49 and 49A. And those forms are now available on the Supreme Court website, www.supremecourt.gov.jm. You can go to the website. The documents are in Word, and you can fill in the information based on your particular circumstances or the
Okay.
facts of your case.
All
So
right.
it makes it a lot easier, especially for self-represented persons.
Okay, so they don't necessarily have to feel intimidated about having to get a lawyer or retain a lawyer. Not that's a bad thing, but persons might feel a little intimidated about the process. They can be more involved in the
Right,
process.
so they can go look at it and then have an appreciation of what, is required. And over time, we intend to, populate the website with more information so persons can have, information at their fingertips to guide them
All right. Well,
in the process.
Well, Ms. Fearon, I don't think I have any more questions left to ask you, and I don't think we have any questions online. It seems everybody seems to understand you perfectly well and understand the process. So I think it's just for me now to wrap and say thank you so much for coming and explaining the process. I hope that now, having seen you or heard you, people are less intimidated by the process and feel like they can just go through and do it and make sure they do it legally and correctly. Thank you so much for joining us. I really appreciate it. Thank you for taking the time.
Thank you for having me.
There are other things that we could be discussing in the future, but that's for another interview, and we hope the person will tune in at that time as well.
All right.
All right. Thank you so much, ladies and gentlemen, for joining us. I am Vaughn Davis. I've been your host. This has been JIS Studio 58A. Please have a good day.